Oh, this is Gara. Dari.
Your name again, ma'am?
Gara Dari.
Yes, and for whatever reason, I skipped your name, but you're also on this case. All right, folks. This is the second hearing. Did we get the money judgment corrected?
I believe so, Your Honor.
Okay. And again, counsel, I apologize for that. It made no sense to me, but yes, we do. We're good. Okay. So where are we now in this case?
Your Honor, last time we met, Miss Dari was stating her case as to why she didn't believe she should be on this money judgment. I'm here with Mr. Glassel, and we have reasons as to why we should. If the other parties are not available, we ask for a
Can take a default as to them. Ma'am,
Yes, sir.
you
Yes, Your
never
Honor.
moved in. Is that correct?
Correct. Due to personal reasons, I did not move in, family health issues. So I reviewed the document or the rental agreement. It says the lease agreement did not stipulate any notice requirement. And so if I had the intent of vacating, or as far as I know, again, a layperson, I can go as far as what I read. So when I made the decision not to move in, that was due to a personal reason. So I never actually, within 2 weeks of actually signing the lease agreement, I decided to make that decision.
Ma'am, but you signed the rental agreement, correct?
Correct. With the intention of moving in.
Understood.
Mm-hmm.
The very fact that you didn't move in, you're still liable under the agreement.
You're right. As far as I understood regarding what was served to me, it was regarding a holdover, which I wasn't aware of any holdover, what was going on with them. I had to reach out to the real estate agent that found the location for me to understand what was actually going on.
Right, that's right.
And that was
a holdover. Yeah. So, counsel, is all of the rent owing after the lease? After the lease had expired?
Correct, Your Honor. The lease. Oh
no, the last time they made a payment was February, I believe.
February, Your Honor, was the last payment we have.
And then the lease, I think, expired March 31st. So I'll talk to Sophia. She informed me that everything was up to date in regards to the actual rent. So it was 1 month.
Your Honor, if I may clarify, or if I may add some light as to our position, it would be the parties were both represented by a realtor. Miss Dari and Mr. and Mrs. Draco's applied together. If my client had thought Miss Dari was not going to move in and be a guarantor, we would have signed a guarantor agreement. It was Miss Dari's income that was used to approve the lease or approve the ability to move in. We were never notified that she wasn't in the location. We were never notified that she moved out, which I guess she says she didn't move in. She corresponded with the landlord as if she was a tenant.
I was coordinating because there was communication.
Hold on a second. But counsel, does the leasing provision doesn't require her to say anything prior to the termination of that lease?
Require her to say anything as far as her moving in or not?
Meaning let's assume that all of the parties just vacated at the end of the lease, March 31st, they just leave. Your client wouldn't have claim for any rent thereafter because they wouldn't be holding over. The lease terminates of its own accord.
Correct, Your Honor. Yeah, I understand. I'm
All
following.
right. So with Ms. Dari, why doesn't her interest just terminate?
So, our position would be that the lease holds everyone jointly and severally liable, and the lease also addresses the holdover period.
Right, but if there are three tenants and one moves out, they're gone. There's no lease. They just leave. You're saying she's liable for the other two staying?
Jointly and severally, we believe so.
Oh, I understand what the lease says,
Yeah.
but she's gone.
So, Your Honor, what we're trying to prevent, or what this could also be, is, and we don't know because parties were represented by a realtor, and my client never met these parties because of the realtor involvement. But we would not. What would happen if she applied just to approve them to move in and then never moved in? What if she was a straw person using credit or income to prove their viability as tenants and then didn't move in?
Okay, what if she did?
That's why we are trying. If we had known that, we would have used a guarantor agreement rather than having her listed on.
I get that, counsel, that things might have been done differently. But the status once she signed is that of a tenant. Whether she moves in or not, let's say she had moved in for a month and then she said, I got to go for whatever her reasons are. I got to go. But the tenancy is still paid for through the end of the lease. But she's not there. She basically has vacated. She's terminated her interest March 31st. Why is she liable for anything in terms of residency afterwards?
We have her listed on the lease as a resident and we're not notified or we did not know she moved out. I mean, she never said, I never moved in. You would assume that she would have mentioned, I didn't move in at some point. But during the entire tenancy, she was corresponding in the group chat as if she were one of the tenants.
Okay, but now she's gone. Let's assume that she was there even, okay? I know she's not. Let's assume that she was there. Come March 31st, she packs her stuff up, she vacates. Why is she liable for any additional rent? She's turned over possession.
Turned over possession to the other two tenants or to us? Possession was never.
She is surrendered because she's left.
She never notified us of a mailing address, or how is the landlord supposed to know that?
Is she required to do that?
Michigan leases require notification of a forwarding address for purposes of the security.
If there's going to be an issue regarding security deposit, certainly.
Yeah, correct.
That doesn't trigger the forwarding address doesn't trigger anything.
So, Your Honor, the holdover provision of the lease would address holding over, and the jointly and severally liable portion of the lease would also state that the parties were jointly and severally liable for that holdover period. It would continue.
Your Honor, may I make a statement? Again, this is not my forte, as green as possible. This is just me doing my research. So I pulled up, and you can correct me if I'm wrong because I don't know this. It says Michigan law on joint and several liability. Under Michigan law, joint and several liability does not extend beyond the period for which I was contractually obligated. Any actions taken by the other tenants after the lease term ended could not be legally attributed to me. The Dracos family have solely decided without my knowledge or consent and continue to live there past the contracted date. Michigan law supports that the tenant cannot be held liable for actions of other tenants once the lease obligations have been fulfilled.
I don't know what you're reading from, but I don't know what you're reading from, but that's fine. That is indeed my understanding.
That's what I pulled from. Yeah. So again, I don't know. I'm representing myself as very minimal knowledge.
No, I understand. I'm just saying she contracts for a year. She fulfills, however that happened, doesn't really matter. She fulfills her obligations for that year. Contract ends. She's not in the premises, which was what the subject matter of the contract is. There are people that may be in the premises. That's fine. But I don't know how her obligation continues.
If her obligation were to end, Your Honor, she would then still be liable for March rent. So we would ask for the judgment for
March rent may be an issue if it goes through March. If March wasn't paid, certainly.
So for
I don't think in anything, and Ms. Dari, you can correct me if I'm wrong. I don't think in anything she has said doesn't hold some liability for the lease term. And she believed that it was all paid through the lease term, but if it's not, she's liable for that. I don't have a problem with that. It's the period in time after the lease ends, because at that point, she's no longer occupying the premises. She never did, but certainly after the lease term, she's no longer occupying the premises.
Respectfully, Your Honor, may I ask, what was the total amount? And I can pull up the contract because again, I was informed by Safia that they're up to date on everything. The actual lease agreement and I can pull it up right now. She's a realtor she noted, like when I got served, I communicated with her. I'm like, hey, what's going on? Yeah. So there was what is the deposit? How much was the deposit total?
the security deposit.
Security deposit, which I'm sure it wasn't sent back to them. They're still a hold.
Yep, we have 5,700.
And how much was rent total?
3,800.
3,800. So
hold on a second. Stop.
Okay.
Just stop for a minute. Counsel, you're telling me that there's a $5,700 security deposit, right? There's 3,800 owing in rent.
No, the monthly rental payment was 3,800. We have rent owing at
1 month.
No, so
folks.
There's two.
We have an alarm going off, so I'm gonna have to stop this proceeding. I'll come back at some point. I'm sure you can hear it probably. Court stands in recess. Okay, I'm trying to remember exactly where we were, but I think we were. It was really the March rent, which was the issue.
And then I'd asked how much the security deposit was, and I think he had stated it was like 5,600, and then the actual rent is 30. I don't even recall the actual total amount.
Right, the rent is 38, but that's only for 1 month.
And that was only
well, but hold on. Even if I think you said the security deposit was 57, right?
Correct, John. Yes.
All right. So give me 57 divided by 3, please. They could take the security as that, but that's going to happen at a different point in time. Have the folks vacated the premises to your knowledge, Mr. Kirji?
Yes, Your Honor, they have.
So does your client have possession back?
He does.
Okay. So he would, yes.
The lease states that the security deposit doesn't have to be used for rent and arrears, and he was planning on using the security deposit for the damages, which are extensive.
Where in the lease does it say that?
Page 1, where it is.
Just one moment, Your Honor. Page 1, the security deposit.
I say in no cases is there obligated. You know what? I'm gonna tell you what. And I'm just gonna be blunt about it, but I mean, I'll listen to everybody, but it seems to me that this individual, Ms. Dari, that all she wants to do is resolve the account. It's a 1 month. And quite frankly, I don't think she's gonna be obligated for anything after that 1 month. And part of, if nothing else, if I were to take the security deposit divided by 3, about $1,900 you have of her funds that could be applied to whatever her rental obligation would be, remaining on that lease. The landlord doesn't want to do that. That's fine. I think the best thing to do is, since I don't have to grant a judgment for possession, I might as well set this for a final settlement conference in a trial. Because I think, and I'll be blunt. I mean, I think she's sitting here, and that the position of the landlord regarding this tenant is whatever it is. I mean, I just don't think it's. I mean, she's not hiding from anything. She seems to be willing to try to resolve it. And I'm not sure that the landlord's feeling that way.
Your Honor, my client.
So I'll resolve it.
If we were willing to take, we may be willing to take the 1 month's rent, but there are other associated fees like an overdue water bill and some HOA fines that did occur before the 31st of March that we would like added to it. But we'll take the 1 month's rent as the court sees for this. Against
Just the other stuff.
So we have overdue water. January through March, $610. We have late fees of $300 and HOA fines.
Late fees of $300 for how much? How many months?
It's 6 times. So, and 2 have been paid, so 4 times. The late fee is $150.
Okay.
I was unaware, Judge. I was unaware of any of this.
Hold on, ma'am. I hear you. I'll hear you, but so there's an additional what? 1,200?
So we have 610 in 600, and then we have a that's correct, 1,200. 525 in HOA fines. So
5 and
25 in HOA fines.
what were those fines for?
There were about 24 HOA violations. I believe it was 24. Various things from leaving the dog leash and the cigarette containers out, trash in the lawn, not cutting the grass, leaving trash bins outside of the garage.
Tell you what,
An assortment.
you guys know how to get in touch with each other. I'm just going to set this for trial. Everybody come with what they have, and then I'm just going to make a call on it. I mean, like I said, I'll just be blunt. Miss Dari is here. If you're going to nickel and dime her, we'll just do it in a trial. And then I can make the decision.
Your Honor, we're not nickel and diming anyone. We're trying to uphold the.
I think you are. I'll be honest with you, counsel. I think when you start talking about HOA, why weren't they collected during the term of the lease from the tenants? Why wasn't there a filing before now?
So, Your Honor, the filing came. There was a negotiation for them to leave. There was an agreement that they would be leaving month, and then they asked for another month, and then finally, when we said we were filing, they vacated the property. So this was an extended period of time where we were expecting the property back.
Okay, but when you weren't, were you dealing with Miss Dari?
I included her on all of the emails.
Which I have.
Dealing with? But who were you dealing with?
Well,
So, Your Honor, even the tenants themselves most of the responses were from their son, Nick Dracos, who may or may not have been living at the property. I'm not sure.
Non-jury trial, June 18th, 2024, 9 a.m. in person. Bring all your exhibits, bring all your documents, and then I'll just make a call on this. Ms. Dara, you
Yeah.
wanted to say something. I'm sorry, ma'am.
No, Your Honor, I don't have anything to really bring other than I'm the one that showed up despite I haven't lived there. The other tenants.
I know, and I just need you to show up at the trial.
Okay.
And then I'll
Okay.
deal with it from there.
And
Okay.
Your Honor, may we submit a default judgment for the other two tenants?
I'm setting the whole thing for trial. I'm not parsing them out. You won't parse them out. I'm not going to parse them out. Everybody be here on the 18th in
June
person.
18th. What time?
18th, June 18th. I'll be in courtroom A. I'll have bells on. Everybody else have theirs.
What time, sir?
9 a.m.
Okay.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you.